Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines where my guest is Scott Perrilloux. Scott is the District Attorney for the 21st Judicial District Court. That covers the parishes of Livingston, Tangipahoa, and St. Helena. He's going to talk to us about the job duties and responsibilities of the District Attorney, how the system works, how criminals are prosecuted, and he's going to talk to us about the parole and probation system. So join us on the next Legal Lines with Scott Perrilloux, 21st Judicial District Attorney. Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines where we're going to talk about the law and you and why it should matter to you what a law is. You know, in America, in our cities, in our states, in our federal governments, they all pass thousands, hundreds of thousands of laws, regulations every single year, and they either directly or indirectly affect you. That's why you need to know what a law is. It's an exercise of power over people, places, and things. So join us on the next Legal Lines where knowledge is power. Hello, welcome to Legal Lines. I'm Locke Meredith. I'm very pleased to have on the show for the first time Scott Perrilloux. He is the 21st Judicial District Attorney. Scott, thank you so much for coming on the show.
Thank you, Locke.
The 21st Judicial District covers what parishes?
It's a three-parish district. It covers Livingston, Tangipahoa, and St. Helena.
And I know Livingston, all of them, but Livingston is one of the fastest growing in the state.
One of the fastest growing, probably in the top 3 in the state, as I understand it. And even Tangipahoa, since the storms, has been in the top 10. So two very fast-growing parishes. St. Helena balances that off. Its population has been pretty static for the last 100 years, they say, but it presents its own set of challenges.
I looked at when you add all those numbers, I was surprised, frankly, to see it's around 260,000 folks.
That's correct, about 260,000. When I took office years ago, it was 190, somewhere in there, so it's really been a growth area, particularly after the storms. And as you know, Livingston provides good schools, and,
right.
and it's been really a catalyst for a lot of growth in the area.
And isn't it also that tri-parish area, it's a huge geographic area?
Yeah, it really is. Tangipahoa is a long, narrow parish. It runs from Lake Marpaw to the state line, and then Livingston also runs from the lake and through St. Helena to the state line. So
right.
it covers and comes to the Amite River to East Baton Rouge Parish. So it is a large geographic area as well.
You said you'd been the DA for a long time, since 1996.
I was elected in the fall of 1996. I took office in January of 1997. So I'm in my 19th year. And I learned something every day.
It was unopposed in 2014.
Yeah, for the first time after 2 contested elections, I was unopposed last year. I think people just, no lawyer in the district probably wanted the job. So I've been very, very fortunate to go in unopposed.
I'm sure you've been doing a great job. Tell the folks what you did before that, because you got a.
Well, I had a civil practice. I was actually an assistant DA under the prior district attorney back in the late 80s, and then I had a civil practice with Mark Rowling. And he and I had a partnership, and still do to some extent. And that's what I did when I decided in '96 to run for district attorney. And be careful what you wish for. You
well,
may get it.
And I read that you had done a lot of different tasks at the city level.
I actually served as an assistant city attorney for the city of Hammond, which that job encompasses being the city prosecutor there. So it's a misdemeanor court, and it gave me some good experience.
Is that where you got your feet wet?
Well, it did, in terms of using discretion, and that's a big part of the
right.
DA's job is discretion.
And I don't think folks really understand that. So with that in mind, explain to folks what a district attorney does.
Well, in Louisiana, the district attorneys are created, the position is created by the Constitution. It's a constitutionally created position. And in Louisiana, DAs have complete control over criminal prosecutions that take place in their jurisdictions.
It's a lot of power.
It really is. I mean, people call it power. It also has a lot of authority, and with that comes a lot of responsibility. So, as we said, it has a lot of discretion. The great thing about the job is discretion, and the downside of the job is discretion.
Right.
So it's something that is just part of the job. And in Louisiana, our system gives DAs, they're very autonomous, pretty much only answer to the voters every 6 years. And with that, we have complete control over charges, who, when, and how people are prosecuted. So, as you said, a lot of responsibility, a lot of authority.
Well, and I know you're very well respected because you've been on the board of directors for the Association of all the district attorneys in Louisiana, and in fact, the president, in 2004-05?
I did. I think I served as president, I think the year Katrina hit, so it was,
wow.
It was a crazy
Holy
year.
moly.
And you know, we have a full-time executive director, Pete Adams, who's been with the DAs.
I know Pete, great guy.
He's been there since the dinosaurs, and he is just so familiar with the system and serves us very well in his capacity as our director.
Well, so explain to folks, kind of give them a day in the life of a district attorney. What's your typical day? And I know you.
Well, what I like to say, Locke, is I'm head of the complaint department, basically, because I'm very fortunate. I have about 20 assistant DAs that work for me. They don't all do what is typically thought of as assistant DA work, which is prosecuting criminal cases. Some of them do civil work. We represent public bodies in the parishes. And some do juvenile, some do child support, but primarily what people think about are the people that assistant DAs that prosecute criminal cases. So I'm very lucky. I've got some people that have been with me a long time.
So they know what they're doing.
They know what they're doing. They're good at what they do. They use good judgment. So basically, the only time that I'm brought into actual cases is when there's really no good opportunity or no good answer, and suddenly I need to make the call. But for the most part, it's administrative to a large extent. We have about 110 employees throughout the district. So every day I have a chief financial officer. She's a CPA. She wears a couple hats. She's probably human resources and personnel in a larger setting. But there's not a day that goes by where she and I don't talk about the administrative part of the offices and decisions that need to be made, whether it's insurance, leave, employment practices, all
There's
types
management.
of things. So,
you wear kind of multiple hats: management,
Right.
administrative, and then a chief
right.
prosecutor.
That's right. And as I mentioned, we're very autonomous, but with that comes a lot of administrative responsibility. We're like a business, like your business. At the end of the month, we have a payroll we have to meet. We have to worry about funding issues. It runs the gamut every month.
So how is the district attorney's office funded? Here, there's a little bit of money that comes from the city, from our mayor and the Metro Council, but as I understand, a lot from the state?
Well, not a lot,
Okay.
not as much as
Y'all
most
want,
people
huh?
think. And that's another topic. But our money that we get from the state funds the DA's position to some extent, not fully, and assistant DAs, and we get a certain allotment from the state.
Okay.
In the 21st, I think we either get 17 or 18 spots that the state, at the current setup now, puts up $45,000 per year. That's it. I mean,
Wow.
nothing for benefits or
Wow.
fringes or anything like that. So if I or another DA in the state wants to pay extra, we've got to figure out a way locally to do that. That's when we turn to parish governments. We also get fines and forfeitures, a piece of that funding. So we're funded by a hodgepodge set of funding that's somewhat complex.
And not guaranteed.
And not guaranteed.
What?
In fact, very speculative. When you talk about funding you get from court costs, fines, traffic tickets, it's hard to really
Right.
budget like that. So,
Well, Hiller
anyway.
Moore has actually told me, and he's the district attorney, as you know,
Right.
for East Baton Rouge Parish. Hiller's told me it's very difficult because the caseloads are huge. You got limited resources, limited folks, and it's just very difficult. And you're trying to keep your head above water in most of the circumstances.
Yeah, Hiller has a much different animal than I do, but it's all the same at the end of the day. It's doing the most and the best you can with the very limited resources you get, and no one wants to pay more for part of the criminal justice system, whether it's prosecution, jails, public defenders, what have you. But it's a very important part of our system, obviously, and we can have the best schools. I take the position we can have the best schools, we can have the best interstates, we can have the best economic development theory out there, but if we don't have a safe place to live,
Right, you're exactly right.
no one's going to participate in our communities.
And I understand you have around a 90% success rate.
Well, we do well with the cases, that actually go to trial. Of course, we choose the ones that we accept prosecution on, so we do fairly well. But that's a big credit to the folks that work for me. I've got some people that have been there a long time, and they do a great job of making me look good, quite frankly. So I'm lucky to have them.
And I assume part of the success rate is the result of the evidence that y'all receive. So let's discuss that on the next segment.
Okay.
This is Legal Lines. Locke Meredith, my special guest Scott Perrilloux. He is District Attorney for the 21st Judicial District Court. We'll be right back. Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines, where we're going to talk about the law and you and why it should matter to you what a law is. You know, in America, in our cities, in our states, in our federal governments, they all pass thousands, hundreds of thousands of laws, regulations every single year, and they either directly or indirectly affect you. That's why you need to know what a law is. It's an exercise of power over people, places, and things. So join us on the next Legal Lines, where knowledge is power. Welcome back to Legal Lines. I'm Locke Meredith. Very pleased to have on the show Scott Perrilloux. He is the District Attorney for the 21st Judicial District Court. Scott, let's dive right back in, and thanks for doing the show. You talked about prosecution. It obviously depends on the quality of the evidence that you get. You're not the ones that necessarily create the evidence that you use.
Right, and that's kind of a misconception sometimes, that we're all kind of locked in together working as one unit. And that's true to some extent, but basically it's not. Law enforcement provides the investigative function of the system. They're the ones that go out and actually do the investigation of the events that take place, determine if they think in their estimation maybe that a crime's been committed. Law enforcement, sheriff's departments, municipal police departments, they can get a warrant. They have the availability to get a judge to sign a warrant, which allows them to physically go and get someone and put them in jail if they think a crime's been committed. But all of that should be based on an investigation where the facts are assembled, and that sets out that a crime has been committed. So that's kind of in general the way it works. I have people call me sometimes and say, you arrested so-and-so, and sometimes I'll stop them and say, wait a minute, I don't arrest anybody. And DAs in Louisiana do not have authority to arrest. We don't. Sheriff's departments arrest people, and police departments arrest people. So it's a good kind of breakdown of the system. There are checks and balances. But you're right, we have to have good law enforcement work done. And there's an old saying that's very true. There's only one opportunity at the beginning of an investigation to get a lot of good evidence.
That's
so,
right.
And if you don't seize that opportunity, that puts us at a disadvantage, and puts the case at a disadvantage in terms of a successful prosecution.
Well, and I know Sheriff Jason Ard, let's say, for example, in Livingston does a great job, has a great department. But the bottom line is you don't even receive the information until weeks after somebody's been arrested. Is that correct?
You're right. I have people that will hear about someone being arrested, and they'll ask me, thinking that I know all about it, a day or two after the arrest, and many times I don't know anything about it, because you're right. Law enforcement is doing their role, doing their function. When they complete their work, they will basically deliver it or refer it to us, and then we'll take it and we'll consider how to proceed with the prosecution. Go ahead.
Well, you indicated that really, in a way, they're also using discretion, as I understand it, as to whether or not they think there's a crime that's been committed?
No doubt about it. Law enforcement has the first line of discretion.
Wow, first door to open.
Yeah, right. And I had a woman this morning tell me that her complaint at the police department has just been shuffled around. I said, maybe it hasn't. Maybe they just decided that it doesn't rise to the level of a crime, and that is their discretion. And I think sometimes it's good discretion.
So does a person or a victim or someone who's been arrested have the ability to come directly to you and skip the police department?
Well, they do. They do. We can initiate investigations. We have some tools available to us under the law to subpoena documents or individuals to appear before a grand jury. But yes, that can happen, but it rarely does in our system. It really, we're not set up to investigate. We don't have the manpower, the training, the resources. That's why we have sheriffs and police departments to do it. They're trained, they're better at it, and that's the way we would prefer it to happen.
So let's explain the criminal charging process. You mentioned the grand jury. There's basically, you can decide to charge a crime, or you can allow a group of folks. Explain to the two systems that we have.
Yeah, in Louisiana, there's two ways to what we call initiate prosecution. One is by way of a bill of information. That's a document that we create in the DA's office, and it's done with the DA reviewing the file, reviewing the evidence, the investigative report, and deciding, I think there's sufficient evidence here to go forward. So we file what we call a bill of information, which is a document with the clerk of court, and that in effect starts the prosecution of that particular case. The second way to do it is by use of the grand jury or bill of indictment, where we present a case. The DA has the authority and has to present the matter by way of evidence, and usually a witness, to the grand jury. And the grand jury makes the decision whether they think there's enough evidence there for a successful prosecution. So they file, if they think it's a good case, they file a true bill. If they conclude that there's not enough evidence there, they file a no true bill. There's a middle ground position too, what we call pretermit, in the event they don't think or they can't make a decision. So that's how we do it. In Louisiana, only two types of cases have to go before the grand jury. Cases punishable by life or by life in prison, or capital cases. Those two cases have to begin with the grand jury process. All the remaining violations of the law can be done by bill of information.
Okay.
And that's the way most of them are done.
And so you have discretion, other than those two instances, as to whether or not it's going to go to a grand jury.
That's correct.
And I'm
That's
not a
correct.
criminal lawyer, and I don't remember, but my recall is the grand jury is more than a typical 12-member jury. And do they have to decide by a majority vote?
Well, they have to get 9 votes, and there can be 12, anywhere between 9 and 12 people there. You have to have 9 have a quorum. So 9 votes constitutes a decision, either a true bill or a no true bill.
And as I understand the process also, they really only hear one side of the case. That is, there's enough evidence here that we think a crime committed and they should be charged with this crime, and the defendant really doesn't get a whole lot of shot at disproving that.
That's true, that's true. It is a one-sided presentation, but I would hope, and I would hope my assistants do this. I mean, we better present things fairly, because if you give birth to a case by way of the grand jury, then you're stuck with raising that case and finishing it off. So you don't want to go in there and get an indictment. And sometimes the grand jury and prosecutors get a bad rap by saying, what's the old saying, DAs can indict a ham sandwich if they wanted to.
Right.
Well, that technically may be true, but it's probably not good practice to do that. And we try to utilize our grand jury for the right purposes, for cases where credibility may be an issue, where criminal negligence, which is a very kind of broad definition, maybe that would fit, and whether we think a body of 9 to 12 non-law enforcement people, what they think about it. And it's amazing the kind of reaction you get and some of the input you get from grand jurors that help you move forward or not move forward.
And so in this scenario, let's say arrest is made, a charge is issued, there's an exchange of information between the attorney for the defendant and the prosecutor, the DA's office, and then ultimately there may or may not be negotiations on what folks here is called a plea deal. Explain that to folks.
Well, plea bargaining is given kind of a bad connotation, but the fact of the matter is it's just a necessary part of the system, whether you call it plea bargaining, charge bargaining. I like to call it just a resolution of cases, and we try to do that in a manner that's good for victims if there are victims involved, and what's good for the community. You know, we don't just go in there and try to resolve cases just for the sake of closing our file. We realize we have some people that may be a threat to the community, may have a serious criminal history, and maybe just it's time for serious consequences. So we try to make decisions on that part, but there's no way we could proceed with trials by jury or judge for the 3,000 or 4,000 cases a year that we open up every year. So some of them have to, as a practical matter, be disposed of by way of a plea.
And you mentioned it, but you actually have a division or folks dedicated to making sure the victims are involved in the process. Explain that to the folks.
Absolutely. We try to make sure that victims are as satisfied as they can possibly be with the system when it's finished, when their case is finished. Does that always happen? No. Sometimes they're not. But we try to make the best decision we can with the victim's satisfaction in mind. And sometimes it works, sometimes it doesn't. The biggest thing we do is try to keep them in contact.
Excellent. All right, we'll continue this on the next segment. This is Lock Mayor with Legal Lines. My guest, Scott Perrilloux, District Attorney for the 21st Judicial District Court. We'll be right back. Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines, where we're going to talk about you and the law. You know, a law is nothing but an exercise of power over you, people, places, or things. But where does that power come from? Where does the government get that power? And how is that power exercised? And do you play a role at all? That's what you need to know. So join us on the next Legal Lines, where knowledge is power. Welcome back to Legal Lines. I'm Locke Meredith. Very pleased to have on the show Scott Perrilloux. He is the District Attorney for the 21st Judicial District Court. Scott, let's dive in. Let's say you get a charge and you take them to court and they're found guilty. And you know, there's a lot of stuff in the news nationally and even locally about the Obama administration, Rand Paul, even the Republicans in the Senate are trying to push on reducing sentences. So let's talk about how the court goes about sentencing, whether you guys are involved in the process, and if so, how.
Well, we're usually pretty involved in the process because a lot of these cases are disposed of by way of an agreement, basically, a joint resolution between everyone involved, defense and the prosecution. The judge does not have to automatically sign off on that, but a lot of times they do, because hopefully they see all the factors that we do. But we have a lot of different resolutions, but sometimes it's jail time and sometimes it's probation. Many people, usually on nonviolent offenses, first offense, do get probation at the state level, and that's usually appropriate, but sometimes it's not.
And so crimes are kind of chopped up into a lot of different ways. You look at the amount of money involved, which is, or whether, like you said, violent or non-violent, whether it's a juvenile versus an adult. Explain to the folks those parameters.
Well, they're treated differently, whether it's a violent offense or a non-violent offense. And Louisiana violent offenses are listed in our criminal code. They're usually offenses that are when another individual is involved, a crime against a person. So those cases under Louisiana law, if they're sentenced to jail, and most of them, when they are sentenced to jail time, you have to serve 85% of that sentence. Nonviolent offenses, some drug offenses, don't have that requirement of serving actual jail time. So a lot of times they get probation, or if they happen to go to jail, their sentence is treated differently by the Department of Corrections, which calculates the time they have to serve.
Did I read it could be as low as 1/3 of the sentence?
It actually can be probably 25% now
really?
and be parole eligible. So I think what we're seeing as a practical matter now, Locke, is the Department of Corrections, and they do a great job with the resources they have, which I think have been cut drastically over the years. But as a practical matter, we're seeing people get out of jail or apply and get pardon hearings to be considered to be released from jail. And we're trying to figure out exactly how, under the law, they are in that position, that they should be serving more time.
And is this a situation because there's just not the money and the resources and the capacity to house all the folks who've been incarcerated?
I don't want to speak too out of turn, but I would suggest that is the reason. And I don't blame the Department of Corrections for looking for ways to make it all work for them from a budget standpoint. But the fact of the matter is, again, we're seeing people that are either being released or considered for release, and according to what we thought, and many times what we told victims, their sentence would be much longer.
Holy moly. This is
again,
really dangerous, though.
Well, I think it presents a risk out there, and I think it's something a lot of DAs are monitoring to see exactly what's going on with some of the people being released. And I'm not criticizing anyone or saying anyone's not doing their job, but again, it's a sign of the times, I think, right now.
Well, and so let's talk about, we mentioned off air that Louisiana is we incarcerate the largest percentage of our population than any other state, and frankly, I understood it was in any country in the nation as a percentage of its population.
Yeah, I'm aware of that, and I would suggest to you it's because of a lot of other, socioeconomic factors out there. We probably lead the nation probably in dropouts and unwed mothers getting pregnant and things like that. All those things eventually contribute, I think, to the crime rate. But one thing I do know about firsthand is when you see someone go to jail in the state system, and I mean actually get a sentence, a jail sentence that they have to serve, most of the time, unless it's an extreme crime of violence, they have been given an opportunity by way of probation, diversion programs, drug court programs, whatever else is out there. Most of them have been given a chance to stay out of jail and just haven't taken advantage of that opportunity. And at some point, as a system, we run out of options of what to do. And from a standpoint of protecting our community and to keep it safe, sometimes jail is the only option. I don't think any judge out there relishes the idea of sending people to prison. And this idea about sheriffs profiting because they house Department of Corrections inmates, they do. A lot of sheriffs do that, but I don't think sheriffs are in it for that. I think that's just part of the economics of the job.
Well, I know Judge Tony Marabella, who's our drug judge in the drug court, has indicated that a lot of the guys he deals with obviously are on drugs, and the recidivism rate of these guys that are coming out when they're not getting some type of treatment, some kind of education or VOTEC education is just sky high. They're going back. It's almost guaranteed, but if we can get them and train them or come up with some alternatives, do you have any thoughts on that?
Well, I think that's a good point, and I think you're seeing work release programs throughout the state now that the local sheriffs are doing. I know Jason has one in Livingston Parish where these guys are working, and I don't think anyone has a problem with that. I certainly don't. During the day, instead of them,
as long as they're nonviolent and don't pose a risk of harm to society.
That's right, and they're out there. I don't think in this day and age they're filling an employment spot that would be taken otherwise. And so at least they're out there being productive. They're putting away some money so when they get out, and a lot of them probably will have the same job opportunity to them when they finish their sentence. So I think we're learning better at it, at programs where people are ready to go and to re-enter into society once they leave legal institutions. But you know, it's a challenge, and the drug fight goes on every day.
Oh, it's
and
unbelievable.
we see it daily.
Well, let's talk about the whole probation system. You mentioned that if it's a violent crime, you've got to serve 85% of the number of years that were put on you or months. If it's not a violent crime, it's significantly less potentially. Explain the whole probation system.
Well, probation is the judge giving you a break and said, instead of sending you to jail, I'm going to leave you out in society, but you're going to be subject to some conditions, and you lose some of your freedom when you're on probation. That's just the way it goes. But if you do everything you're supposed to do, if you follow the conditions that the probation department puts on you, if you stay drug-free, if you stay criminal-free or crime-free, you finish your probation and then you are back in part of society again.
I think I saw
some instances they allow you to maybe have your conviction expunged from your record and your arrest expunged, which is huge when you talk about getting employment out there.
Right.
So I think the system is set up, if people really want to, can take advantage of opportunities.
And you mentioned, is there a public-private coalition developing in these work release programs?
I think there is.
Is that a private sector being involved?
I think there is, and the sheriffs would be better able to explain that than me. I don't know that much about it because I don't have anything to do with it, but I think it is, and
interesting.
And it's, I think, a good concept that has some value.
Explain the diminution of the sentence. That's a concept, or a term I'd never heard before.
Yeah, it's a fancy term for good time. Basically, the Department of Corrections calculates based on some statutory authority a diminution in sentence. So at some point you get credit. Nonviolent offenses, you get more credit. I don't know if they're giving 2 for 1 or 3 for 1 these days. But diminution in sentence on a violent crime, 85%, I think, calculates to you get a day of credit for every 17 days you serve somewhere.
Interesting.
Okay. So that's a Department of Corrections math that they do every day over there to keep up with the thousands of people in the system.
And the bottom line is the State Department is the one that's in charge of administering that whole program.
Correct. After we convict them and they go to jail, and I tell this to people all the time, they become, and I'm not trying to be critical, they become the property of the Department of Corrections.
Excellent.
Okay.
Thank you, Scott. Very much appreciate
Enjoyed
you being
it.
on
Thank
the
you
show.
very
This is
much.
Lock Mayor with Legal Line, Scott Perrilloux, District Attorney for 21st Judicial District Court. Thank you for being with us.